Any further amendments? Yes, Ms. Trahan, you're recognized.
Thank you,
to
Mr. Chairman. I have an
discuss your
amendment at the desk titled Trahan 27.
The clerk will report the amendment.
Amendment to H.R. 4312, offered by Ms. Trahan. Page 18, strike line 6 through 22. Page 25, after line 15, insert the following, and redesignate subsequent sections accordingly. Section 8, enforcement.
Without objection, the reading of the amendment is dispensed with, and gentlelady is recognized for 5 minutes in support of her amendment.
Oh, thank you, Mr. Chairman. My amendment would give athletes and enforcers real tools to hold bad actors accountable. It would allow the FTC to enforce the SCORE Act by treating violations as an unfair and deceptive act. It would also give state attorneys general the ability to bring civil action on behalf of student athletes enrolled at institutions in their states. And if government enforcers lag, under my amendment, athletes would possess a private right of action to seek relief when all other avenues fail. Listen, I appreciate the chairman's attempt to codify athletes' NIL rights and institute baseline requirements on institutions, particularly on health and safety. And as I've made clear in this markup, although I think those provisions could go further, they are a reasonable start. But I must ask the obvious question. Regardless of the scope of athletes' rights or the level of requirement on the NCAA or schools, where is the enforcement? What if schools infringe on an athlete's NIL right? What if a university fails to uphold its health and safety commitments? And especially if we're granting broad exemptions from antitrust liability, how else can violations be held to account? A right that is legally unenforceable is not a right at all. It's just words on a piece of paper. And I know that my friends on the other side of the aisle understand this because just 2 months ago, we moved a piece of legislation called the Take It Down Act through this committee. The Take It Down Act, which was later signed into law, didn't just require online platforms to take down non-consensual intimate imagery. Its authors explicitly tasked the FTC with enforcement authority. I suspect it's because they knew that without enforcement, the bill would just be a bunch of empty requirements. My amendment would set up a modest enforcement mechanism for the SCORE Act at the federal, state, and individual level. It would simply ensure that the rights and requirements in the bill aren't left toothless by a dearth of enforcement. Thank you, Mr. Chairman. I yield back.
Thank you. And any further discussion on the amendment? Mr. Fry, you're recognized.
Mr. Chairman, thank you. I move
minutes.
to strike the last word.
You're recognized.
Mr. Chairman, the SCORE Act would create a much-needed national framework for college sports that offers the stability, clarity, and transparency that stakeholders, including college athletes themselves, have been calling for. The proposed amendment, however, would undermine the SCORE Act and put college athletics on an unsustainable ground, much like they currently are now. The amendment creates a new private right of action that enriches trial lawyers rather than protecting students. And if you look at the recent House settlement, $500 million went to the pockets of the lawyers vis-a-vis attorney fees. Think about that. $500 million that could have gone to supporting hardworking college athletes instead of paying for a lawyer's second home. This amendment should be titled the Trial Lawyer Protection Amendment. The SCORE Act puts students front and center. This amendment puts trial attorneys front and center. I urge my colleagues to vote no.
Will the gentleman yield? Will the gentleman yield?
I yield back to the chair.
Oh.
Any further discussion on the amendment? Yeah, you're recognized, Ms. Cass.
Thank you very much, Mr. Chairman. I think Rep. Trahan's amendment is very well taken because here we have with the House settlement, the court settlement, and the SCORE Act, you have a total rewrite of college athletics. So now universities can directly pay student athletes. This is setting up, along with the settlement, the court settlement, revenue sharing, and then athletes can also still have outside name, image, and likeness deals. Okay, so what happens under revenue sharing if a college or university says, okay, we're going to pay the student athlete, and they never do? what is the recourse? Because reading the SCORE Act, that was one thing that really jumped out to me. Okay, how does a student athlete appeal a decision or enforce this? And there's just nothing there. And then if you read it along with that very broad preemption section and liability shield, there really is no recourse at all for the student athletes. So I think this is an important question. It's a reasonable question. If you really want to help student athletes, this is just something that's fairly routine. Mr. Chairman, is this something else, another one of the issues that we can possibly work on together before the hearing, the markup next week?
We'll discuss it, but I will tell you this, that basically if the school violates this particular policy that's in the bill, the antitrust exemption will be removed.
That's why, and that's a good point. Too, that kind of goes back to Rep. Tran's previous amendment or idea on sunsetting this. That might be one avenue, but I'll yield the balance of my time to Rep. Tran.
Thank you.
You're recognized.
Thank you, Congressman, for yielding. I just want to make sure I heard that right. What is going to be the governance in terms of revoking the antitrust
Well,
exemption?
I'm making a statement, and it's in the bill, the particular bill at hand, that if there's a violation of this particular legislation by the school, then the antitrust exemption will be removed.
So it'll be-
that's an enforcement mechanism, as far as I'm concerned.
Okay, so I would have a lot of questions, and maybe we can work this out in the time, I guess it's a week, that we have between now and when this gets marked up full committee. I mean, there isn't a plan for enforcement, and what I'm unclear on is who's actually going to bring that violation, who's actually going to enforce that violation, and then the exemption that gets revoked, is that the whole antitrust exemption that is applying to the conferences and to the NCAA is no longer? I mean, I don't read the bill that way, so I just want to get clear.
Let's, again, I want to talk to you about this.
Okay.
So let's set a time.
I just want to make, we are.
No, listen, you're making a legitimate
Okay, I appreciate that.
request, and let's make it better if we possibly can.
And one thing that
So
while
there-
I have the time,
Okay,
because
go
I
ahead.
want to compel the rest of the committee on this, there is no enforcement mechanism. There is no recourse right now for states or for individuals. There is a liability shield into perpetuity with no sunset, no revisiting by Congress. And so I want us all to, understand that deeply before we go ahead. Because it doesn't feel pro-player to me. It doesn't feel like this is an extension of athletes' rights. It feels like we're putting a couple of modest player protections in a bill based on what we know right now and not being able to revisit it later and
And
not
I'll
giving
be
them
happy-
tools to advocate for
Gentle lady
themselves.
will yield. I'll be happy to work with you on this, but again, if the terms of the agreement is violated, the antitrust exemption will be removed. So I think there is an enforcement mechanism, but we can
So
have further discussion.
So
Mr.
this
Chair,
was,
will you
I
yield?
think this was my time, and
Okay,
that, with all due respect, Mr. Chairman, that's not going to be good enough for the student athlete that doesn't want to get into it for revocation of the whole liability sheet. They just want fairness. They want to be paid what they entered into. They want enforcement of the contract. They want their scholarship that they were promised. It's that kind of basic student enforcement. And I'll yield to the chairman of the committee. Well,
Gentle lady's time has expired. I'm going to recognize the chairman of the full committee, Mr.
So
Gosselin.
my understanding how it works, and I'm talking to my good friend here, Mr. Fryer, the Judiciary Committee, who's working on the judiciary side of this, is, so currently, I know that there's been schools that advertise, we're going to pay this player $9 million. That's one real example. And then the money never comes to fruition, it never happens. Or a player takes money and they show up at a school, then they transfer before the end of the year. And that's supposed to try to get a handle on that, where schools deliver what they promise and then players live up to their contract. So my understanding is, as the NIL contracts are individual. So if I'm a great athlete and you got to tie it. I mean, if you're the star player at Kentucky, you're probably worth more money than if you're a star player at another school. But not in again, basketball. So that increases your value. I get it. But those are individual contracts with individual groups. So the revenue sharing, my understanding is schools are going to have contracts with these students. And so the students can, so this doesn't supersede any contract. So if a player chooses to come to University of Kentucky and said, here's your $500,000 for playing here, and then they don't pay, then they still have rights and contracts. Understand that to my counsel here.
Will
is
the
that-
gentleman yield?
Sure.
I
That's
think
my understanding.
That's what we
I
want to
think-
have happen, so we need
I
to
think
make sure.
that-
Understanding
I
as
think
well.
then
You're
the-
recognized. You're
I think
recognized.
that the SCORE Act would then need to spell that out. And then they're thinking through all of those situations for the student athletes and the institutions on how they're going to enforce. But right now, it's silent on that.
Well, I mean, this doesn't, to spell out, I mean, it's like, it doesn't, contract law is still contract law. So I know you're an attorney.
But not when
but,
you have a broad preemption where the language says you're preempting all state laws, rules, regulations. So that obviously needs to be clarified because that would not be consistent with my understanding or your understanding.
Okay, I'll yield to my friend from South Carolina.
Thank you, Mr. Chairman, for yielding. I think the liability shield actually just talks about antitrust laws or other similar state laws related to antitrust. I don't think, to the chairman's point earlier, if you have a violation of a contract, you still have a private right of action to enforce the terms of that contract. And so I think we're getting ahead of our skis here. This deals with antitrust specifically or similar rules, laws, and regulations on books for states. But for a traditional violation of contract, those things would still be in play.
I see my good friend from Massachusetts itching to say something, so go right ahead.
Well, because we're ignoring the combination of the liability shield and preemption. So I just don't understand, like, what recourse does the athlete have when you have those two together? And maybe the general counsel would just read the liability, section 7, because that's where it all becomes very vague, but yet very clear that there is no enforcement mechanism and there is no recourse for the athletes.
You're
Thank
recognized.
you. Thank you, ma'am. Section 7, liability limitation, compliance with this act, and the adoption of, agreement to, compliance with, or enforcement of any rule, regulation, requirement, standard, or other provision established pursuant to or in compliance with this act shall be treated as lawful under the antitrust laws and any similar state law, rule, regulation, requirement, standard, or other provision having the force and effect of law.
And so then I would just ask the question, I don't mean to interrupt, but who determines compliance with?
So I can, in the definition section, antitrust laws, the term antitrust laws has the meaning given to such term in the first section of the Clayton Act, 15 U.S. Code 12, and Section 5 of the Federal Trade Commission Act, 15 U.S. Code 45, to the extent that such Section 5 applies to unfair methods of competition.
Still not clear on who, who is going to determine who's going to be compliant with this. I mean, I think that is where we need to start this conversation. If we can continue to debate this amendment, but I would just argue that it's silent on that. There is no enforcement mechanism in this bill. There is no recourse for athletes. If there's no injunctive relief, there's nothing. They have no place to go. If all the things that we spell out in this bill, which are meager at best, are not honored.
Okay, well, again, yeah,
Thanks.
the
So,
chairman wants to address this.
Well, so it's still my time. So we're looking at, we want to make sure this is clarified. So the idea is that you have currently schools promising players money, not delivering. You have players receiving money and then transferring. That's the current. So we're trying to even the playing field where there can be contracts. Now the limit is the $20 million that can be revenue shared by the school, and how that's divided up by contract. And we just need to make sure. So that's, for your points are well taken, and we want to make sure the law does what we want it, the bill does what we are all expecting it to do or hoping that it does or want it to do, and we need to make sure the language is clear. It says compliance, what my chairman was talking about, it says compliance with the act and adoption of agreement. So you have to comply with the act to get the protections. And that would be somebody could sue and go to court. They have a right of action, say the school's not complying with the act. So that, but if we need to clarify, be more clear, then we can do that. We can work on it together.
I pledge to you.
I'll
that
yield back
we
my
will
time.
discuss- We will work on this together. 'Cause
I'll yield back,
the
Chair.
intent- Yeah, yeah. All right, I'm going to, and again, you know, like what Mr. Fry said, this is contract law, and you have a private right of action. We're not taking that away with regard to the contract. All right, I'll yield 5 minutes to the chairman or the ranking member of the full committee, Mr. Pallone.
Thank you, Mr. Chairman. You know, I want to go back to my opening statement in light of the debate that we've had here for the last couple of hours, and then ask the chairman, I guess, of the full committee, you know, an issue here. You know, what I said in my opening statement was that I believe very strongly that the courts had basically framed what's been going on now with college athletes and the issues that the SCORE Act tries to address, and that we shouldn't get in the way. In other words, I don't think we should have a bill at all, because I think that the history of college sports and the NCAA is to simply exploit the athletes. And that exploitation, I'm afraid, would continue with this bill. We'd be much better off letting the courts and you know, what we've had now for the last few years continue to frame, to set the framework. Anything else, I worry, would simply lead to more exploitation of athletes. I heard the gentleman from South Carolina, no disrespect, you know, criticize the fact that NCAA and the colleges are spending so much money on lawyers. Well, the only reason that we've had success and ended the exploitation to some extent of college athletes is because they've been able to go to the courts and use the lawyers and make their case. You know, that's what the system's all about. That's what the rule of law is all about in democracy. So to suggest that somehow that's a bad thing because the colleges or NCAA has to spend money, well, that's too bad. They were the bad guys. They were the ones that were exploiting the athletes. They should have been spending money defending themselves. And fortunately, they failed no matter how much money they spent. Setting this framework legislatively, I don't believe is going to help. However, I do recognize that many of my colleagues on the Democratic side do feel that if this bill was amended and it was clarified, and that's what the debate has been about for the last 2 hours, that they might be willing to support the bill. The problem that I see, though, is that my understanding, Mr. Chairman, Chairman Guthrie, is that you know you're ready to go to full committee on this next week because after that we have the August recess. I would ask, you know, you don't have to say yes now, but I would ask that that not happen. I think it's quite clear, based on the debate, that this bill is not ready to go to the full committee. And if you're seeking to have members, and even possibly myself, you know, support a bill, there have to be some major changes and major clarification of what is going on here, which is not the case. So I would ask, you don't have to answer now, that we not go to full committee. This is not ready at this point. I'm sure the rest of the debate today will even make that more clear. If you'd like to, if I'd yield to the chairman if he likes, but you don't have to answer right.
And I'm not going to commit to a schedule on this, but I take your comments under advisement. We want to get this right. We want to make sure it's correct. We feel like we have a strong bill. If we need to clarify what the intent, I do believe, because it says that you have to comply with the act to get these protections. If you go through the act, you have to provide comprehensive academic support, medical benefits, grant and aid provided to student athletes. You have to have if you go to have 12 varsity sports, says we're only going to have 12 because we can't afford 16, you're not complying with the act. So I think it's in there, but we'll take the time to make sure we get it right. And I'm not going to commit to a timeline because we need to discuss it, but I appreciate your comments.
Thank you, Mr. Chairman. I yield back, Mr. Chairman.
Gentleman yields back, and again, I think we're doing pretty well here today in these discussions and this markup and making the bill even better. So the input has been very productive as far as I'm concerned. So we need to move forward. We have the ranking member of the subcommittee, Ms. Schakowsky, is recognized for 5 minutes.
Mr. Chairman, I think it's so clear now through all the discussion and the issues that have been raised on the Democratic side that this bill is not ready for prime time. And it seems to me that if we want to have a bill that really addresses the needs of our, the needs that we've been talking about, that we cannot say that this should be voted on. And I think that we need to agree to that and not to move ahead until we get these questions all answered. They're all very, very relevant, and it would be a mistake to move ahead.
Well, let me remind the lady, if the lady, gentle lady will yield, that this is a bipartisan bill. And I know there's several members on the Democrat side that are interested in co-sponsoring the bill. And they've told me that they're really happy with the product, but they want to work further with us. So I think we're making a great deal of progress. And I really think that the system is broken and it does require legislation. Okay? Will the gentlelady yield? She yields back?
Yes.
You yield back, okay. If there's no further discussion, the vote occurs on the amendment. All those in favor shall signify by saying aye. All those opposed, nay.
Mr. Chairman, we want a roll call.
Okay, the gentleman requests a roll call vote. So the clerk will call the roll.
Mr. Fulcher? Mr. Fulcher votes no. Mr. Dunn? Mrs. Kamick? Mr. Obernolte? Mr. Obernolte votes no. Mr. James? Mr. Bentz? Mr. Bentz votes no. Mrs. Houchin? Mr. Fry? Mr. Fry votes no. Ms. Lee? Ms. Lee votes no. Mr. Kane? Mr. Kane? Mr. Kane votes no. Mr. Evans? Mr. Evans votes no. Mr. Goldman? Mr. Goldman votes no. Mr. Guthrie? Mr. Guthrie votes no. Ms. Schakowsky?
Yes.
Ms. Schakowsky votes aye. Ms. Castor?
Yes.
Ms. Castor votes aye. Mr. Soto? Aye. Mr. Soto votes aye. Mr. Han? Mr. Han votes aye. Mr. Mullen? Mr. Mullen votes aye. Ms. Clark? Ms. Clark votes aye. Mrs. Dingle? Mrs. Dingle votes aye. Mr. Veazey? Ms. Kelly? Ms. Schreier? Ms. Schreier votes aye. Mr. Pallone? Aye. Mr. Pallone votes aye. Chairman Bilirakis?
No.
Chairman Bilirakis votes no.
Kelly?
Mr. Dunn is not recorded. Mr. Dunn votes no. Mrs. Houchin is not recorded. Ms. Houchin votes no. Mr. James is not recorded. Mr. James votes no.
Anybody here? We're good? Miss Kelly, how is she recorded?
Ms. Kelly is not recorded. Ms. Kelly votes aye.
All right, the clerk will report the result.
Mr. Chairman, on that vote, there were 10 ayes and 13 noes.
The amendment is not agreed to.